Time is short. Let me jump to some other considerations. Again, if all of that was bad was the only thing that's gone wrong, it would be bad enough. But I regret it gets worse. When the government brought forward Bill 107, the government and its proponents said that one of the big problems with the old system was that there was a gatekeeper at the gate of the Human Rights Tribunal, pardon me. It was the Human Rights Commission that would decide which cases went forward, and they repeatedly talked about how few cases actually go to a hearing. They said the new system would have no gatekeeper. We believe the data before you will show that they've just changed gatekeepers. There's a new gatekeeper. It's called the Human Rights Legal Support Center. They get 10,000 calls in 6 months. They do, I am sure, the very best they can. They are dedicated and hardworking people. They interview, I believe, a proportion of the people who call them. They've advised a smaller proportion, and they have ultimately drafted complaints or applications for, we've been told, about 200 or so applicants and another couple hundred more coming. A very small fraction of the 10,000. That is de facto a gatekeeper role. Now, again, if that was bad enough, we'd have a lot to be worried about, but it gets worse. We were told the Human Rights Tribunal would adopt proceedings that would be fair. The Human Rights Tribunal, over our objection and those of many other community groups, opted to use the power that the government gave it to override the requirements of fairness in the Statutory Powers Procedure Act. Mr. Gottheil this morning made it sound like we're trying to come up with old technical criminal law proceedings at the tribunal. Far from the truth. With respect, it's just not our position. We want some basic fairness. And we quote in our brief one ruling that should give members of this committee concern. I don't want to talk about the merits of the case. I don't know anything about the merits of the case. But in a case called Prasad, one tribunal adjudicator, a Mr. Mark Hart, decided before a hearing began to dictate to the parties how long they could examine in chief or cross-examine each of the witnesses listed. An hour for this one in chief, an hour in cross, a half hour here in chief, a half hour in cross. And he said, if you've used up your time or if you're not happy with this, I'll consider an extension, but you've got to first identify that you use, or prove to me that you used your time effectively. Now, with respect, and I'm not commenting on the merits of the particular case there, this is exactly the kind of potentially unfair proceeding about which we are very concerned. It is impossible in advance to have an adjudicator who does not know the witness, hasn't interviewed the witness, doesn't know all of the ins and outs of the case, to know better than counsel calling the witness how long they need to examine them or cross-examine them. The tribunal gave same time for chief and for cross. It's not unusual in cases for a witness to be very short in chief, very long in cross, or the other way around. And finally, the tribunal, deciding that they would give people the opportunity to ask for an extension after or near the end of their time, after they've already used it up, puts counsel in a hopeless position. You've got to know how much time you've got before, not after you've used it. The last area of concern, I know my time's just about up, but I just want to talk about my last area of concern. A hugely important issue. By the way, I can't say how prevalent that practice is. I'm just simply advising that that is a decision which is an indication of an area of concern which merits, I believe, more attention by this committee into the powers the tribunal is using. Now, final area of concern, public interest remedies. It's not enough when somebody is discriminated against, if they prove their case, to give them some money and say, go away. If that happens, the claimant may be happy to get some money and go away, but that doesn't prevent it from ever happening again. That's why we need public interest remedies. The party that was in the lead of seeking public interest remedies under the old system was the Human Rights Commission. Now, of course, they're ahead of the game for most of these. We are very concerned. We wrote the tribunal and asked how many cases they're giving public interest remedies in settlements, and we haven't got any answers on that yet. We hope they're able to pull that information together. But of course, there are 6 reasons that I'm going to summarize and then I'll conclude why you should be very concerned about this under Bill 107. First, the government said that under Bill 107, the Human Rights Commission, even though it was out of the business of dealing with individual cases, would be in the vanguard of bringing public interest cases. Guess how many they've brought under Bill 107? 0. That's their number, not mine. Under the old system, they've got 1 still outstanding. They've done 1 inquiry so far, but they've brought 0 commission-initiated complaints so far. So that's one of my 6. Number 2, the government said that the Human Rights Commission could intervene in individual cases. This was an avenue, for example, to bring forward public interest concerns. How many of the 1,200 new applications have they intervened in under the new system? According to the Human Rights Commission, 1. Well, it's 1 more than 0. The government told us that the Commission would retain investigative powers. But look at schedules or appendices 4 and 5 appended to my brief. They've laid off all their investigators. How can they investigate without investigators? 4th, the government said that the Human Rights Commission would be empowered to do this through 2 new secretariats that Bill 107 requires them to establish: the Anti-Racism Secretariat and the Disability Rights Secretariat. You go down to the Human Rights Commission, you can go all through the building and look for them. They don't exist, contrary to the requirements of the Human Rights Code. And finally, I only have time for 5. Finally, the government said that we could be confident that disability would be a priority amongst the Commission's work. You'll see that while they have done some important work in disability, and I'm sure they'll do some more, their priorities set out in their strategic plan, which we quote, sets mental health as one of their priorities, but no other disability issues, a bunch of others. And we're very concerned that we're going to fall potentially to the lower end of the priority spectrum. Let me conclude by thanking you again for giving us the opportunity. I wish we would have been able to do this 3 years ago. And we welcome the chance to come back to talk more about this as you get more data. We encourage you to have full hearings. Invite not just those of us who are here today, but anyone else who was of the hundreds of groups who were frozen out. And finally, we encourage you to, on all sides of the House, to unite, to have the government keep the promises that it said it would under Bill 107. Thank you very much.
Well, thank you very much. And you did mention that you had 6 and that you went to 5. We are certainly here to hear number 6 if you want to add
Okay,
that.
that's fine. I just want to make sure I didn't go over my time.
No,
all right.
Go ahead.
6th concern is this. This is really fundamental to us. Remember I said that the Disability Act that we fought for and won and proudly won in 2005 was the underpinning of it was the Human Rights Code. And we're very proud that the government brought it in, and we're very proud that both opposition parties united to support it. That was an incredible day back in 2005 when it was passed. Let me talk about what happened leading up to that bill. One of the things that Premier McGuinty promised our coalition in the 2003 election was that that Disability Act would have effective enforcement. When Premier McGuinty got elected, his government asked us what effective enforcement we wanted. We said we would like a new enforcement agency to enforce the accessibility requirements independent of the government. A long discussion with the government, and the government ultimately elected not to give us that new enforcement agency. And I was the lead negotiator for our side of the table. They were very good negotiations, and in good faith, we were told, I believe, the government believed that we would have enough to be able to continue to use the investigative and prosecutorial functions of the Ontario Human Rights Commission. We didn't get everything we wanted in that bill, but we shook hands and celebrated its passage as an overall good deal. A year later, the government turned around and ripped out the Human Rights Commission's investigative teeth and its enforcement teeth. In other words, the very enforcement agency that we were supposed to be able to fall back on was essentially eviscerated. And that, we say, is not fair. It undermines the Human Rights Code, but it also undermines the Disability Act, for which all 3 parties so properly and wisely united to pass. And that is a breach of faith. It is a breach of commitment. It is fundamentally unfair. It is also something that we wanted to come and be able to say to a committee of the legislature 3 years ago. Only a closure motion precluded us from being able to say it in here. We had to do it at press conferences or letters to the editor.
Well, thank you very, very much, and we appreciate your being here today. As you might have realized, we have exhausted the time that is available, but I'm very pleased that we were able to offer you the opportunity to make your final comment. And thank you very much for being here with us today.